Okay, we're going to go back on the record then. Time is 2:21 p.m. December 17, 2019. About a commission of judicial discipline back in session. We have taken a brief recess. Is Respondents Counsel ready for the next witness?
Yes, Your Honor. Judge Bennett.
Judge Bennett. Step over to the stand, please. Please face me, raise your right hand and be sworn. Do you solemnly swear you testify to write this matter as the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please be seated. Please state your full name and spell your first and last name for the record, please.
My full name is Karen Bennett-Haron, K-A-R-E-N. My middle initial is P. B-E-N-N-E-T-T-Haron, H-A-R-O-N.
Thank you. Go ahead, Mr. Pitaro.
Thank you. Judge Bennett, we all know you're a judge in the Las Vegas Township. How long have you been a judge?
Since 2002.
Did you ever serve as chief judge?
Yes,
And how many years did you do that?
4 years.
And do other judges come to you and ask you questions about administration, things of that nature?
Yes.
I want to direct you to the book right there in front of you. If you go to page 166. Yeah, the 1-0167 in the, okay. Paper.
Yes.
Yes.
Make sure you got it. It's looked like a memo.
Okay. Title memorandum for record.
Yes.
Okay.
I want to direct your attention concerning that document. It references a conversation that you're a participant in with Mr. Denson and Judge Chelini.
Yes.
Do you remember that incident?
Yes.
Okay. And I had, prior to your testimony, I believe, I sent a copy of that note over to you.
Yes, you
to
did.
look at.
Yes, you did.
All right, and you looked at it.
Yes.
All right, can you tell me what the situation was of why Judge Chelini came to you?
If my memory serves me correctly, Judge Chelini came to me because her clerk at the time, Marisha, complained that she had received information that her supervisor, Maggie, I don't even know her last name, was disclosing confidential personnel information to a third party premises, and she was very concerned about it.
And did she ask you what you thought should be done?
Yeah, she did. Actually, what she expressed to me was concern about the fact that there was this disclosure of the information, but also she was confused because the court administrator at the time had committed or made representations that Marisha would be no longer under the supervision of this lady, Maggie.
And did you then participate in the telephone conversation with Mr. Denson?
Yes, I initiated it. I contacted Mr. Denson, who at the time was acting as the court administrator, and inquired as to whether or not Kim Camplin had left word that the transfer was to take place.
And what did he say?
He said, no, he didn't know anything about it, and I think he said something to the effect that the investigation was over.
That the investigation was over?
Mm-hmm.
And
Yes. Was that a yes?
I'm sorry, yes, I'm sorry, yes.
And did you and or Judge Chelini make any request of him?
Well, I did, because I told him that there was concern about this disclosure of confidential personnel information. And he said that he hadn't received any information about that. And I said, well, what would be the protocol that one should follow in terms of requesting that that be looked into, because that's very serious.
And what did he say?
He said, to be honest with you, I can't remember verbatim, but it was something to the effect that it was a county something or another, or it was maybe he made reference to the collective bargaining agreement, I don't know. But it was not really a response. He just said he didn't have a complaint and he wasn't going to transfer Marisha.
Do you think it was appropriate to ask him, you and Judge Chelini, to make this request to transfer, given what was happening with Marisha Parker?
Well, neither of us requested that she be transferred specifically, but we did ask whether or not the transfer was going to take place based upon what Ms. Campbell had represented to Judge Chelini, and to inquire about the status of an employee who's under a judge's direct oversight. I can't imagine a more appropriate inquiry. And at the time, not only was Mr. Denson the division administrator for the criminal division, but he was also acting as the court administrator, so I'm not sure who else I would have asked.
Now, in this note, if you could just take a look at the page 166, he says that you two demanded he do it.
Yeah, I see that.
Is that your recollection?
No,
And your recollection is what?
that I inquired as to the status of the transfer that Kim Campbell had represented would be completed prior to her departure on FMLA, that he responded by saying he didn't think the transfer was appropriate and he didn't know anything about any commitment that Ms. Campbell had made, and that he didn't have a complaint filed by Marisha about the disclosure of confidential information.
And then what happened?
So, okay, thank you.
And that was the end of your involvement in it?
Yeah, that was the end of my discussion with Mr. Denson, yes.
Thank you. Let me just turn it now to, I want to turn to a more general thing. During the period of time that you've been in justice to it, you know Judge Tobiasson,
Yes, yes,
and you know Judge Chelini,
yes,
and you see them every day?
just about.
All right. Let me just ask you this, the attire of Judge Tobiasson, have you ever seen it dressed inappropriately in court?
No,
Have you ever seen it dressed inappropriate out of court?
I'm not the fashion police, but no, I don't think I've ever seen her dressed inappropriate.
And one last thing, did you ever hear excuse me 1 minute. I have nothing further.
Okay.
Any questions, Mr. Terry?
One question.
Go ahead.
Judge, in your opinion, does either Judge Chelini or Judge Tobiasson pose a substantial threat of serious harm to the public or to the administration of justice?
Absolutely not.
Prosecuting counsel, cross-examination.
Judge, during this last break, were you intently talking with two witnesses that previously testified in this case?
I don't know if they previously testified, but I was speaking with Brazil Hernandez and Judge Susan Bacham. I speak to them on a regular basis.
So you guys were sitting just out here, correct?
Yes, we were sitting out
And
there.
you're sitting very close to each other, almost huddled into a conversation. Is that a fair
We were
statement?
sitting next to us. I don't think I was huddled with anybody. I've been
Oh,
sitting
oh.
out there all morning with them, as a matter of fact.
Almost knee to knee. Wouldn't you say you were so close?
No, I wouldn't say that, but okay.
So you guys were in the middle of this fairly intense conversation, and you suddenly stopped talking when you saw me staring at the three of you, correct?
Sir, I don't mean to be disrespectful, but I've never seen you before in my life. I don't
You
know
what?
who you are. I have no idea who you are, so I wouldn't quite.
Did you notice that Brazil Hernandez stopped talking as soon as she saw me?
1 second, Mr.
Did
Terry.
you finish the answer?
Yes. Make sure you give her a chance to finish the answer.
I thought she was finished.
Okay, good.
Finish your answer.
I don't know who you are.
I think you said that.
Okay.
All right. So, Grizel Hernandez suddenly stopped talking when she saw me. Is that a fair statement?
No, I didn't notice that.
We can agree that it's inappropriate for you to discuss your testimony with either of these two people that just finished testifying, correct?
That
Absolutely.
assumes facts not.
Yeah, but
I didn't say, I'm saying,
Stop.
It
Mr.
would
Terry,
be a-
just
it would be
stop, please. Mr. Terry, state your objection for the record.
Assumes facts not in evidence. Why don't he ask the direct question? Did you discuss anybody's testimony?
I said, I can ask whatever questions I want, and I said, would it be improper? And I want her to answer that.
I'm going to permit the question, restate the question for the witness.
Would it be improper for you to discuss your testimony with two witnesses who just finished testifying?
It would if I had given testimony or had some planned testimony, I guess. Is
Would
that
it
what
be
you're
inappropriate for them to discuss their testimony with you?
asking? Depends, but they didn't, so.
That wasn't the question.
I said it depends upon, are you suggesting?
I didn't ask you whether, I said, would it be inappropriate for them to discuss their testimony with you, knowing that you were going to testify?
It could be, yes.
So you're on the same floor with both, with Judge Tobiasson and Judge Chelini? I'm sorry, with Judge Tobiasson?
With Judge Tobiasson,
Right.
her office and her courtroom are on the 8th floor along with mine.
And have you overheard her use the F word in the hallways or outside her chambers?
What's the F word?
F-U-C-K?
Okay, no.
And have you heard her use the word bitch?
No, in chambers and
In
the
chambers or the
hallway?
hallways?
No.
Have you read the 1,000+ pages of the Commission's investigation in this case?
No, I haven't.
Have you read any portion of it?
I read the portion that Mr. Pitaro asked me about on Exhibit 1-0166.
Have either of these judges described this Commission investigation as a witch hunt to you?
No. There are several people who do describe it that way, but they haven't been done.
That's all I have, thank you.
Any other questions?
Thank you.
Or do I?
Okay, can the witness be excused at this time?
Thank you.
Yes.
Okay, thank you so much. You're free to go.
Yep.
Thank you. Okay, let's get another.
I do have one question if I could.
Sure.
One
final question from Mr. Pitaro.
just one. Did you discuss your testimony with anyone outside the moved courtroom prior to coming in to testify?
No.
That's all I wanted.
Okay, thank you so much. Let's get another update on time, just so we're aware.
Prosecuting officers have 11 minutes remaining, respondents have 14 minutes.
11 minutes for prosecuting, 14 for respondents counsel. You wish to call out the witness, respondents counsel? Okay.
I don't hear anyone saying she can't order a change of custody if she follows the right procedure. you're going to convince me to hold your client in contempt.
Raise your right hands, face the court clerk to be sworn.
Sitting judges get contempt wrong all the time.
I find you in contempt. I am going to incarcerate you.
Any statement that you make is under penalty of perjury.
Nope, that's not how that works.
Read your right hand next word. Do you solemnly swear any testimony provided this whole truth and nothing but the truth, so help you God?
I do.
Please be seated. State your name and spell your last name for the record.
Amy Chelini, Amy Chelini.
Thank you. Go ahead, Mr. Pitaro.
Judge Chelini, when were you elected a justice of the peace in Las Vegas Township?
It was June, one of the primaries, June 2016. I started January 2017.
And you've been the JP ever since?
Yes, sir.
All right, we don't have much time, so I want to go very quickly.
Okay.
Bringing the kids to court, that was in 2017.
April 2017.
Now, in 2017, there was an incident with, in the hallway,
Correct.
and that was with Marisa?
Correct. That was with Marisha and Elizabeth Coda.
Okay, and what happened?
I was in the hallway. My courtroom was in Joseph Sanford's courtroom at the time. It was 8C. The administration put my courtroom next to Judge Tobiasson's because we both had domestic violence court. It made it better for the victims, victim witnesses, DAs, etc., so they could have the courtrooms right next to one another. I turned and I heard a lot of commotion. I saw Marisha crying. I saw her son, who was about 16, 17 years old, he was a huge kid, walking toward Elizabeth saying, "Why is my mom crying?" At that time, Judge Tobiasson intervened, grabbed the son, and took him into Judge Sacento's chambers.
Did you ever call her a bitch?
Never happened.
What about Judge Tobiasson?
Tobiasson wasn't there, she was in Judge's chambers, but in Judge's chambers, Sacento's, but no, she did not say that. And I can guarantee you, if one of us had called somebody a bitch, particularly a supervisor, you can't sneeze in the RJC, the courthouse, without everybody knowing about it. Everybody would have known about it. That never happened.
Okay. Now, the issue with Marisa and Mr. Well, let me go back with Marisa. There was testimony about Marisa and a typing test.
Correct.
Okay, tell the court of commission what happened.
All right, well, Marisha was clerking for me on an interim basis for about 6 months. And I had the domestic violence court at the time. She worked as close to me as you, this commissioner right here. And things are crazy and chaotic. It either works really well or it doesn't. And when you have a staff that works well, things run smoothly. And so she was doing a great job. She had to apply because of the county rules for the permanent position. She indicated to me she wanted to do so, and she did so. Evidently, you had to also resubmit a typing test. She neglected to do that. Now, I had gone and I had asked Kim Camplin, who was a court administrator, I said, is there anything we can do because we clearly know she can type. She's been doing the job for 6 months in the most chaotic court that exists. And she goes, let me check with HR. By HR, my understanding was Melanie Long. She checked with Melanie Long, got back to me. She goes, I don't think there's anything that we can do. I went to Judge Bennett, and I've gone to Judge Bennett before, and I will continue to go to Judge Bennett on administrative questions because I have to tell you, I don't know of any judge in Justice Court that knows more about administrative matters than Judge Bennett. And it's no offense to anyone else, but that's why I tend to go to her. Let's report this down the state court. And I asked her, I go, in your experience, is there anything we can do that's a shame for me to lose somebody who's working so well? She was asked him if they will reopen it. We reopen it pursuant to the contract. You have to open it for everyone. And I asked her that. She said, that's a good idea. Let me check.
We have a question in here somewhere.
There's a question.
It's an answer.
There was a question about what had occurred, I believe, Mr. Karl, is that correct?
Yeah.
Go
And
ahead.
so I had asked if there's anything that we could do. And during that time, again, Bennett said, see if they'll open it up for 30 days for everyone pursuant to the SCID contract. So she did that. She got back to me and she said, they said that we can keep it open. That's a great idea. And that's the last I heard of it. I didn't think there was any big deal with that whatsoever.
Now, you didn't call HR, did you?
I don't know who called HR. I wouldn't even know who called it. No, to answer your question.
But the answer was, it was open for everyone?
It was open for everyone. I believe Judge Zimmerman's clerk got, Judge Baca. There's about 6 other clerks that were able to get in because Kim did indicate there wasn't that many people that applied anyway, so it worked out for everybody.
Now, you've been sitting here, so let me direct you to the alleged complaints against Mauricia. On those complaints, are you aware of any complaints being sustained against her?
I think there was one that was sustained for lack of communication.
And that's been resuscitated too with Melanie.
Correct.
Long. And then the other one was unsustained.
Correct.
Now, concerning the placement of clerks, is it normal that judges have input into other clerks in their department?
It is. It's been common practice.
And did you make a request that you wanted Marisa?
Yes,
Why?
because she's great at what she does. I mean, that's the easiest answer I can give you. I mean, you work hand in hand with the clerk, as well as my backup clerk. I have another one, Deanna Cochran, who I love as well, who's been in there. And I don't believe anyone has ever spoken to her, but they work hand in hand. It's not just a judge. I mean, you guys know this. It's not just a judge. The clerks run the courtroom pretty much. I mean, when we practice, we always said that you better be in good with the clerks, right? And it's almost like a machine. They both work, they sit as close as you two are sitting right now, the two commissioners, and then I'm sitting right next to them. And so it's a product of everybody working together, getting attorneys in, getting them out, making sure the minutes reflect what exactly happened, sending over the custody stats to the jail, so if people need to stay in or stay out when they go. They're showing the time section.
We gotta go quick, we're gonna go
Sorry.
2 minutes. Let me ask you this then about calling Dave Benson concerning Maggie Tucker.
Correct.
What happened with that?
I went into Judge Bennett. I was concerned because Mauricia was upset. She had been to UMC 3 times. The complaint, she had that complaint with the coaching and counseling hadn't been resolved. It had been going on for well over 3 months. And prior to Kim leaving, I didn't know she was going on FMLA. I had told her about the concern I had that Maggie clearly appears to have a bias against Mauricia. Would it make sense just to switch? When I say switch, I mean a lateral move. Okay, so there's no change in pay, no change in office. You have the same. She just would go from departments 1 to 8 instead of having, I guess, 9 to 15, whatever it is, the number. All right, and that was it. She indicated that was a good idea because Mauricia had learned some information that Maggie had given out some personnel information, and she was pretty upset, and that she had said something negative to her about speaking poorly with other staff members. So I said, do you think it'd be a good idea if we could switch them? And she said, yes. Then she indicated she was going to do it. The next day she's on FMLA.
And that's the last time?
That's the last time we ever talked about it. And I asked Dave if he said no.
Okay. And did you ever ask anyone else after that? Like
No, that ended at that time. They didn't do it.
I want to go back to a clerk by the name of Menfa and Pro Tem Judge Straversky. Could you tell the court, the commission, about that situation?
I was gone that day. Judge Holly Straversky had had pro tem for me as a judge. It was domestic violence court. Nifa had gone in. She was the clerk that day. Mauricia wasn't there. She wasn't experienced in domestic violence court. They got a call. It was about 12:30 in the afternoon. They were still on the 8:30 calendar. So things were going really slow. And with DV, you really don't like that because you don't want the victims and everybody around and waiting. And plus it's chaotic. And she didn't know how to get the forms because you have to give gun forms for if you're convicted of domestic violence. She didn't know any of that. Subsequently, I had a meeting I brought in Kim and Dave and Maggie, and I let them know what my concerns were about that, and, well, you heard Maggie testify that she agreed that Ethan wasn't qualified to sit in that position that day.
But in fact, this was brought to your attention by the pro temp.
Yeah, Mr. Bursky.
And you brought it to the attention of the
Yeah.
administration.
Correct.
And she hasn't been back since.
No, she hasn't. She can come back to my courtroom. I just said until she's better trained in domestic violence court, she shouldn't be in there. But
So
she
you
can
haven't
absolutely
blackballed
go.
her from
I
your...
didn't blackball anybody in my courtroom.
No.
No one.
Now, there was talk about Arisa,
Correct.
that there was a problem with her.
Wasn't a problem with me. Evidently her and she filed a bullying complaint against my clerk. But there was no issue with me.
And has Arisa actually clerked?
Not since, and she clerked for me actually, on Nevada Day, she clerked for me. I was the on-call judge. There wasn't any issues whatsoever.
All right, so you haven't blackballed her?
No, I mean, during the harassment complaint that she had filed, that came back that Marisha has to communicate better, I assume they didn't put her in there on purpose. I mean, why in the world, from a management standpoint, if someone has a harassment complaint, would you sit them right next to one another in the same department? That's just common sense. So, I mean, I didn't. I just thought that was just them using their common sense not putting her in there.
And
She's been back since.
Did you ever ask or demand of Kim Kaplan to not give a coaching counseling to Marisa?
Never. And I can tell you about it's hard to be.
Oh.
We just
And the last thing is you heard testimony that when you would call Kim on the phone, that you would say, "What's up, motherfucker?"
Yeah, I'm glad you asked that question because I was about to come out of my shoes if you didn't. Never said that. It never happened.
Okay, Mr. Terry, do you have any questions?
Any time left?
How much time do we have?
4 minutes.
4 minutes, Mr.
4
Terry.
minutes. One question.
Okay.
In your opinion, does Tobiasson pose a substantial threat to the serious harm to the public or the administration of justice?
Absolutely not.
I wish I could ask that question of you, but it's...
Go ahead.
Go ahead next, okay. You feel you pose a substantial threat of serious harm to the public or to the administration of justice?
No, sir, I do.
Ross?
Thank you. Judge, you referenced the Marisha complaint. You didn't realize that complaint against Maggie for giving out information to a third party was not sustained?
I don't know if it was or not.
You don't know that?
No, but I know she was also speaking about her to another employee, and that concerned me more, participating in gossip with, somebody you're supervising is not the way that, I don't think it's a professional thing to do.
I realize you dispute using the phrase, "What's up, mother effer," with Kim Campling, but had a judge use that terminology, we can agree that would be a violation of the judicial code, correct?
First off, you're right, I do dispute it because it never happened.
And second, I'd object to the last part because that's not her decision. It's your decision to see if she is violated, not to make
I
sure.
want to know her understanding of the code.
I'm going to permit the, for a minute in the past, I'll permit the question. Go ahead.
Can I answer?
Go ahead, please.
I mean, I think that it depends, everything depends on a context. I mean, we live in a situation where wasn't there just a U.S. representative that won and said we're going to impeach that motherfucker? And everyone like puts her on TV, she's on every news station that there is, and she's like a forum for the Democratic Party. I mean, if you're talking to friends and you say, "Hey, what up?" I'm just going to say it because we all know it. "What up, motherfucker?" And you're talking as friends, and you're not, that's one thing. But if you're calling somebody just out of the blue in administration saying something, then yeah, I can see a problem with that, sir.
And can we agree that, as a judge, you're supposed to treat the court administration group in a patient, dignified, and courteous manner?
That's correct.
Now, I'd like to talk to you just briefly about why you think this case is a witch hunt.
Why do I think it's a witch hunt?
Yeah.
Because first off, you're coming at us but for allegations that are, even if true, are personnel issues that occurred in, March? I mean, it's got to be an immediate threat. And everybody who's heard this says the same thing. This doesn't make any sense. I mean, you've literally got two people that have done nothing wrong, that try to run their courts efficiently, and yet you keep coming. And you've tried through your questions to get inappropriate questions toward this judge, and it's been no secret that you guys have been after her forever. That's why I think it's a witch hunt. And you're smiling because you obviously agree.
I'm smiling because I like your answer.
I'm sure you do.
Is there anything else that you'd like to share with the commission about your feelings? It seems like you need to
Yeah,
share.
I'd like to share and tell you I'm completely innocent, and so is she. And this is wrong, and it's a complete waste of taxpayer dollars to make us be here for this. And the only danger to justice or the administration of justice is this prosecution right now. I'm not talking about you guys, obviously.
Anything else?
I can go all day, but I should probably stop.
No, go ahead.
No.
That's all I have.
Any other questions?
I'm tempted, but no.
You're tempted. Mr. Pitaro, do you have any other questions?
I get one last. It would seem strange if you weren't upset over this thing.
Yeah, I have a whole new respect for when I admonish defendants that are sitting at the table and they say they didn't do it, tell them not to make a face because it was impossible for me to do that today and yesterday.
Of nothing.
Of course I'm upset.
Any other questions from the prosecuting counsel? Thank you, Ms. Depp. Anyone else call or respond to counsel?
How much time do we have?
That's our problem.
How much time do they have?
3 minutes.
3 minutes.
Is everything closed?
No, I think closing's in a different category.
Okay, good, 3 minutes.
May we huddle for a moment? We're not asking for a break, we just need.
Okay, go ahead and huddle.
It's harder for me to huddle.
We have 5 potential additional witnesses in 3 minutes to get them on. First day of this proceeding, I said I was concerned because of the time duration. We're sitting here at roughly 5 minutes to 3. You would ask for at least an additional hour. And we have no objection to the prosecution getting an additional hour. That will take us close to 5 o'clock. Either that, or I have to make a proffer as to what these witnesses would testify so that I create an adequate record.
Mr. Bradley, did you have something?
Both sides have known for weeks that we have 6 hours each. We planned our case knowing we had 6 hours. They planned their case knowing they had 6 hours. The fact that they over-listed number of witnesses does not make a reason for this commission to change its ruling. And it would be unfair to the prosecution to suddenly open up more time at the last minute. So I would object to any further time.
I would remind the commission that in Halverson, who was the special prosecutor that asked for more time, the commission gave it to them. That was not found to be any form of error. I think it's more egregious if the respondent is attempting to put witnesses before you in an effort to rebut that which the special prosecutor has presented and we're not afforded it. How, if the court chair does not allow it, I make a request to make a proffer.
I think we're going to take a very brief recess. I'd rather confer with the other commissioners before I make a decision. So we're going to take a 5-minute recess. Okay, we're going to go back on the record then. Time 3:01 p.m. December 17, 2019. The Matter Commission of Judicial Discipline is back in session. We're taking a brief recess to consider a question that was posed by Respondents Counsel. I'm going to afford an opportunity to both Respondents Counsel and the prosecuting attorneys to make a proffer of what testimony or evidence you might produce if either side were afforded an opportunity for additional time. Based on what is in your proffer, I'll make a decision on whether or not I believe it's warranted to allow any additional time. So since you were the moving party, I'll allow you a chance to get your proffer first, Mr. Terry.
Thank you very much. Members of the commission, we have 5 additional witnesses that are present. I'm going to go through them one at a time. Melinda Harris is a deputy public defender. She has worked in both departments with Judge Chelini and Judge Tobiasson. She would testify that she's never witnessed any swearing in court, that both of these judges run a very efficient court. She will testify in reference to the importance of the clerks and her observations when there hasn't been a good clerk in that court. Additionally, we have Melissa Navarro, who is the Chief Deputy Public Defender, again, works in both courts. She would testify to similar situations as Belinda Harris. We have Socorro Carrera, who is the regular clerk for Judge Tobiasson. She would testify to her duties and responsibilities, the necessities of having a very efficient clerk, and her relationship with Jose and the fact that they work together very well. We would offer you Jose Espinoza. You have documents, all of his performance evaluations. We think that he's important in order to explain the fact that some of which has already been testified to, that he was only advised on the day of the transfer, which did not happen, that he was being transferred. Number two, he's never received any written complaints, never. And number three, as to the importance of his position in that department. Final witness, and my colleague may want to add to this, Marissa Proctor is the law clerk, is the clerk for Judge Chelini. She has worked with Judge Chelini for a long period of time. You've heard some testimony regarding her, but she would testify as to the importance of what her work requirements are, the fact that she has to have knowledge and speed. And I think this all goes to what Judge Zimmerman testified to, which is a judge should seek the necessary docket time, court staff, expertise, and resources to discharge all adjudicative and administrative functions. Pardon me, responsibilities. That is our problem.
I'd like to just add that as far as Marisa, she would testify as to the incident with bringing your kids to court day. She was a participant in it. She can testify from her perspective what happened and where the problem arose. That's one. Two, she would testify to the situation with Ms. Ninfa, last name, first Vincent, and then the situation with Risa, which were those two complaints. She'll testify that she's never been notified of any court counseling, saving except the one on the second complaint. And that second court counseling was not bullying or harassment, as prosecution witnesses have said. It was, as Melanie Long testified to, it was not harassment, it wasn't bullying, it was communications. She'll also testify to, we have all her evaluations in there, and then the last evaluation she had, she'll testify that there was a portion in there which was relating back to Maggie Tucker, when Maggie Tucker was her supervisor. But the person that wrote the evaluation was Jennifer Adair, and she'll testify how Jennifer Adair put in there that apparently she had problems before Jennifer Adair took over, but since then she hasn't had any problems. She'll also testify too that she filed a objection, if you will, which is the right of the employee, an objection to the that paragraph in there stating what was happening, the problems with this Maggie Tucker, the supervisor, and the complaints, as well as the review says that she didn't do a class, and that's why she put in her objection the email that she received that Melanie Long testified she wrote and to her, and in there it says the supervisor will set this class up for you when it is available, and she'll testify they have never set that class up to her, and the evaluation is wrong with it. Says she didn't go because I haven't set it up. I'll see you later. So that is the additional proffer from Marisa. Thank you.
We have a minute.
Sure.
I've been back for.
Thank you for your indulgence, Your Honor. As the court noted in Halverson, this is not the final hearing. There's no formal statement of charges yet. There may never be. It's just a question of whether or not these respondents should be suspended. Weeks ago, this commission determined that 6 hours was appropriate. We planned our case and got it completed within the 6 hours. We would be prejudiced now to all of a sudden extend it because we planned to have a certain number of witnesses testify in a certain amount of time. We don't have people sitting out in the hallway because we believe the commission would honor its rule that said 6 hours. Now, as far as the proffer goes, the very first thing that Harris was going to testify to was there was no swearing in court. And neither of these judges have been accused of swearing in court. We've heard testimony upon testimony about the importance of an efficient clerk, how important the clerks are. So all of this is cumulative. The same goes for Navarro. With regard to the existing clerks, we've heard ad nauseum all about whether or not the complaints against Jose and Mauricio were justified or not justified. I don't think any additional evidence is going to be needed on that. And then the importance of whether or not this one individual can work well with Jose or not, again, that's not a major issue. So I would ask the court to allow us to do closing arguments at this time.
Mr. Aaron. I'm going to deny the request for additional time. The order that was filed by the commission set out some time ago the time parameters that were involved in this proceeding, the responsibility of counsel to manage that time. I'll note for the record that the Halverson case, I think, was set for 1 day. For an argument to be made that it involved even more serious allegations than are in this case. And we, of course, provided 2 days for this consolidated proceeding. And so I'm going to deny the request for any additional time at this point. We're going to move on to closing arguments. If either party need a break before you get ready for your closing arguments.
I'd like to step out and advise those witnesses
Sure.
that, consistent with your ruling, they are now relieved of the responsibility of the subpoena, and that with your permission they can come in.
That's fine. Go ahead.
I'll wait for my colleague to address you and then.
No, I was just going to say that I'm ready to go.
Okay, so if you want to let them know, Mr. Terry, we'll get started here in a moment.
And it would be reserved 10 minutes in rebuttal.
Okay.
Your Honor, the 5 witnesses that had been subpoenaed have now entered the room. I have advised them consistent with your directives.
Okay, thank you. We're going to begin with closing arguments then. The prosecuting counsel, and you reserve 10 minutes for rebuttal. Go ahead, either counsel.
May it please the commission, I respectfully disagree with the Honorable Amy Chelini. This is not a witch hunt. The commission put in a great deal of time and effort to investigate these 2 respondents. Over 1,000 pages of investigatory materials were put together. And I believe that combined with that information and the information and evidence that was adduced over the last 2 days, there is a preponderance of the evidence that both Judges Chelini and Tobiasson pose a substantial threat of serious harm to the administration of justice. Under Halverson, this commission is supposed to evaluate the evidence based on the totality of circumstances. So even if 1 or 2 incidents by themselves may not warrant discipline, this commission should examine whether or not a combination of these incidents constitute evidence of a continuing pattern of misconduct, which may warrant significant disciplinary measures, including suspension. I'm not going to go through the evidence piece by piece that this commission has just heard and examined. I believe that the evidence shows multiple code violations by both of the respondents. I think the evidence showed that the respondents used profanity and abused the persons in the court administration. That was not just inappropriate in and of itself, but it was part of misconduct that was designed to show the court administration that these judges and their clerks were not subject to their control, that these judges did what they want and they would protect their clerks. I think the commission should consider the following factors in whether or not these judges do pose a threat. First, we've got absolutely no admission of wrongdoing, no acceptance of responsibility, no promise to change behavior, no regrets, no apologies. In fact, we've got a lecture from both of these judges that the commission was misusing the taxpayers' money and was acting inappropriately. Their seeming inability to understand the flagrant use of profanity as a violation of the code is appalling. Their rude, demeaning, and harassing treatment of court administration is also appalling. The problem is they don't fully appear to understand that their roles as judges require them to act something else than high school-esque. I mean, I believe it was Mr. Denson that described their behavior as high school and high school-like, and I agree with that sentiment. There seems to be no appreciation for the fact that this commission has a responsibility to protect the administration of justice, and instead that Judge Tobiasson complains that the commission looks into every detail. But I suggest that's exactly what this commission is supposed to do. The respondents point out that the misconduct that's alleged in this case is outside the courtroom, and they seem to think as long as it's outside the courtroom, they can act as they wish. They can be inappropriate, but our judicial code in Nevada says something completely different. The code has numerous requirements about how a judge is supposed to act outside the courtroom. And that for them to keep trying to raise the straw man of, everything in the courtroom is fine, that's not the relevant question. The question is, was there conduct outside the courtroom in violation of the code, and does it pose a threat? And I suggest to you that's exactly what the evidence proved. Clearly, judges have a need for clerks who are properly performing their jobs. But instead of running roughshod over court administration, the respondent should have worked with them by requesting more training, keeping the court administration informed, and not insisting on, this person has to be in my courtroom, you can't move him, or you can't move her. You can't discipline this court clerk. You have to revoke any sort of counseling or coaching that goes on. That is not how the system is supposed to work. The respondents are adamant they only provided proper input, but I would suggest the evidence showed much different evidence, that they improperly interfered with almost all attempts to relocate the backup clerks to other departments, and the totality of the evidence shows almost constant interference, verbal abuse, in a harassing manner. These were not individual, isolated events, but a pattern of practice was shown to interfere with the court administration. The problem is that if both of these respondents are completely adamant that they did absolutely nothing wrong, then undoubtedly they are going to continue to act as they have. And that poses the threat. The threat is if they are allowed to continue to act this way, they are not going to stop. And it may embolden them to even do worse things. One of the issues that was briefly touched upon is what happens if these judges, by interfering in personnel decisions, allow a hostile work environment to be created. And although generally judges have immunity from liability for monetary damages for acts they perform within their judicial function, judges have to be careful when acting outside their judicial function. For example, the United States Supreme Court has held that judges do not have immunity for their administrative decisions, such as hiring and firing employees. A judge may also be liable for harassment, employee disputes with court workers while serving as a judge. I believe that Ms. Campling and Ms. Cota briefly touched on those issues. The law in Nevada is fairly clear. Under Chapter 4 of the Nevada Revised Statute, it lays out what duties and obligations the chief judge has. And it's also laid out in the local rules of practice for the Justice Court for Las Vegas Township, 6.5. And essentially, it allows the chief judge to be involved in the personnel decisions. It does not allow the regular judges who are not chief judges, such as Judge Bauckham and Judge Chelini, to get involved. Almost each witness who testified for the prosecution said, all I want to do is my job. All I want to do is my job. And Judge Chelini and Judge Tobiasson tried to prevent them from doing so and effectively discouraged them from even attempting to exercise supervision over their clerks. The administration staff, instead of being treated in a courteous, polite, patient manner, was treated with bullying, harassment, and essentially a rude, demeaning manner. The totality of the evidence demonstrates an utter lack of judicial temperament by these judges, and given that they claim they have done nothing wrong, these judges will continue to act exactly the same and nothing will change. To protect the integrity of the judicial system and ensure the fair and timely administration of justice, this commission should immediately suspend both respondents, and I would reserve my remaining time.
Thank you, Mr. Bradley. Closing statement, Mr. Pitaro.
Thank you very much. And I can't recall if we're limited in our time. May I make that inquiry?
I believe it's 30 minutes that you have.
Per side.
Per combined, you and Mr. Pitaro combined have 30 minutes.
All right, then I'm going to ask if you could let me know when I have 5 minutes left. I'm going to assume that Mr. Pitaro will take 15. Okay, 15, but let me know when I have 5 left. Fair?
Okay.
Fair. Members of the commission, we have no charging document in this case. What you have is the complaint. And I want you to take notice of what stage the proceedings we're at. This is not a formal hearing. And what I mean by that is we've constantly heard throughout the course of these proceedings that this is an ongoing investigation. So my colleague, for example, is highly critical of these two judges for a lack of acceptance of responsibility. Respectfully, we haven't hit that stage yet. I think that particularly Judge Chelini's testimony indicates that she certainly is not happy to be here. This is a proceeding that only has been done 3 times, to my knowledge, in the state of Nevada in the history of when this commission has had the opportunity to suspend with pay. One was Judge Jones's case, clearly not applicable. Neither of these judges have been indicted by a federal grand jury. Okay. 2 is the Halverson case. So the only guidance we have from Halverson is to look at the facts of Halverson. And there were 4 allegations and 4 things that the Nevada Supreme Court addressed themselves to. An inability to adequately conduct criminal trials. That was number 1. You don't have that issue here. That's why we stressed to you in our opening arguments that this is not any fact situation that occurs within a courtroom. Everything is critical to the functioning of the court, but not one fact has been testified to in reference to any dereliction of duty lack of communication, treating an individual in a harsh way by either one of these judges. So clearly you don't have that like you had in Halverson. 2, abusive behavior to court personnel, including sexual harassment. You have 0 sexual harassment in this case. If anything, it's interesting that Judge Zimmerman's testimony was, if there's any form of sexual harassment here, it has to do with women's attire and not necessarily being pro what some men judges wear underneath their robe. No question but that any type of allegation dealing with attire does not take place in the courtroom. Number 3, creating a hostile work environment. And that is the specific allegation in this case that you have before you. But you don't have a hostile work environment. You have what everybody has testified to as a right of input. And again, at this point in time, remember exactly what Judge Zimmerman testified to. 2.5, a judge shall perform judicial administrative duties competently and diligently. Without good clerks, you don't have that ability. But more critically, a judge should seek, in the commentary, a judge should seek the necessary docket time, court staff, expertise, and resources to discharge all adjudicative and administrative responsibilities. The buck stops here on these 2 judges. If those clerks mess up, it's their responsibility. Sort of like a lawyer having a paralegal do a bunch of work, the buck stops at that lawyer. So you don't have a hostile work environment in this case. Number 3, falling asleep on the bench. Not even close in this case. Nothing pertains to their inadequacies in the courtroom. 4, failure to cooperate with colleagues and court administration. Interesting, in Halverson, judges tried to help Judge Halverson. The judges that tried to help these 2 individuals are the ones that testified to the workings of the court system and to the fact that these 2 judges do not pose a substantial threat to the administration of justice or to the public. Respectfully, I disagree with the charging document. The charging document leaves out an important word, remembering that what we're here for, which is, do these 2 judges today pose a risk to the public or to the administration of justice? The word current should be in the admonition. It should read, pose a substantial current threat of serious harm to the public or to the administration of justice. It doesn't use the word current. But one of the factors you have to take into consideration, for example, this whole situation with the bring your kids to school, what a dilemma. But when does it occur? April of 2017. So you're being asked to suspend with pay these 2 judges for an act that occurred 2.5 years ago. Even taking into consideration when this commission brought forth these allegations.
Excuse me, Mr. Terry, you have under 5 minutes left.
I have under 5 minutes left. Okay. I will save it for a vote.
I'll give it.
You'll give it to me? Okay.
I'll give it to someone.
The only thing else I would add is you have to look further at engaged in a pattern of, and I won't repeat all the words, but, and created a hostile work environment. My colleague argues that if you go to the market and you wear an inappropriate sweater, that is a violation. It may or may not be. I don't think it is, but that's for this commission adjourned. But that's not what they alleged here. Creating a hostile work environment, not creating a hostile supermarket problem. If you look at this case, really what you're dealing with, I think everything has been explained about the clerks and the interactions between the clerks and the importance consistent with the rules. But what you're really looking at is swearing and attire. One day, one sweater, big thing. Judge Bachman explained that. It's sort of like beauty. It's in the eye of the beholder. No one took offense. Even the person that took the picture thought the sweater was cute. Okay? Now suddenly, when the special prosecutor introduces 3 witnesses that have been terminated from the court system, suddenly it becomes exceedingly offensive. Swearing, no one testified, with one exception, and that was to bring the kids to court, that any type of swearing were directed to an individual. In other words, the example I used was damn. Damn you is much different than damn. Both are considered swearing, but it's like beauty. It's in the eye of the beholder. It's not directed to an individual. So even if you believe that Judge Chelini, for example, answered the phone in the way that she did, it is not a derogatory way. A lot of testimony was that there was other swearing. I'm overusing the time I want to reserve.
Excuse me, Your Honor. I don't believe that respondents can reserve time after the prosecution. The prosecution gets to go first and last.
Well, then I yield to Mr. Pitaro.
Okay.
I don't want to, but I'm limited by time, and I understand that.
Okay. Counsel, go ahead. Closing argument.
Let me be brief, Mr. Trey. That's probably not true. Let me just say this. Here's what we're looking at. We've got 2 judges, and we've had most of the testimony in this hearing, which determines the immediate threat, appears to be directed at, should Denson have been fired, should Carter should have been fired, should, Kim should have been fired, is Giselle a good or a bad court administrator? That seems like we were in an employment trial, none of which has to do with these 2 ladies. What I can say about these 2 is that the evidence shows that they are good judges. Now, I get to say it because Amy came in first. Now think of it. You were asked by this side to say that Amy Chelini should be removed from the bench because she is such a threat. And yet, 2-3 weeks ago, the RJ poll, UNLV poll, which is relied upon quite heavily down here, came out and put her as the top judge in Justice Court in Las Vegas Township, with a rating higher than any other judge in Las Vegas Township, a rating higher than the appellate court and the Supreme Court. She is supposed to be a danger, an immediate danger, a threat so bad you have to pluck her off the bench. The same thing with Judge Tobiasson. She's been on the bench and her ratings are high also. Her ratings are well above average. And so this is what you are faced with. You're faced with the reality of good judges and 3 people who are pretty darn mad that they get fired. Well, everyone understands that. If I got fired under these circumstances, I'd be mad. But listen to some of the evidences that you're talking about. Let's just talk with Judge Chelini, that she would get them, they had to do what she wanted. Well, most of the testimony with Dave Benson was, he didn't do what she wanted. With Kim, she says, Amy wanted to pull something back. She said, I wouldn't do it. With Judge Tobiasson, same thing. I wouldn't do it until I was overruled. That seems awful strange that the only instances they brought forth that there has been nothing where they forced them to do it or got them to do it. And the big, well, we have a scheduling problem. Look at the schedules. They're all there for this whole period of time. There's nothing that indicates a scheduling problem with Amy or with Melanie. Neither of those has scheduling problems. And so I think what we're talking about here, remember, this is like the death penalty or being stuck in the isolation ward waiting for the death penalty or trying to remove them now. You gentlemen and ladies have obligations. You have an obligation, and one of those obligations is to say, no, you're wrong. We shouldn't remove them. They are good judges. They work hard. They get the job done. Very, very difficult. As we've seen in the past, Las Vegas Justice Court is one of the most busiest courts in the United States, and they perform excellent. And so that's really what we're saying. All I can say in conclusion on that is, no, don't do it to Amy Chelini. Don't do it to Melanie Tobiasson. The reason is because it isn't warranted. I mean, I cannot imagine that the highest rated judge in Las Vegas Township is removed by this commission because someone said she swore. Well, actually, that's right. They didn't say she swore in the thing. Is it she supposedly said, which she has denied, and which we gave corroborating testimony from Giselle Hernandez that it didn't happen, of saying, what's up, motherfucker? Which is a colloquial. If you're my age, those words were never used. Now, all you do is turn on any TV, and that's all you will see. You know, the songs, that's a common sort of thing now. And you're not going to remove judges for those sort of things. We remove them when judges are bad judges. And you gentlemen are lucky, and lady, you're lucky because these are what we call good judges. They care about the people that work for them. They care about the people that come before them. And they try to do that what they're supposed to do. Efficiently administer justice impartially with fairness. And you haven't heard one statement from anybody that Judge Amy Chelini and Judge Melanie Tobiasson aren't fair and aren't efficient, and they do the job that needs to be done. A tough job, the toughest job in the toughest court probably in the United States. And I think you have an opportunity to make a statement to us, to the community here, that you recognize that. And nothing happened in this courtroom. Nothing happened in their courtroom that warrant this sort of thing. And so when Amy says, yeah, it's a witch hunt, think of how it is with her. One day she's the most popular, or the highest rated judge in Las Vegas Township all the way up. And the next day she gets a statement saying, you were a threat to the administrative justice, so I have to remove you. Gentlemen, I think the answer is clear, that on this motion by the state, or the prosecution or prosecuting attorney, however we refer to it, should be denied, and let these two ladies go back to their job. And if the commission has other information, then we'll deal with it then. Mr. Terry and myself are not afraid to deal with it at the time that it is appropriate. But as he says, we don't even have a complaint. Thank you.
You have anything else, Mr. Terry, I assume?
I do not.
Okay. Prosecuting counsel for your rebuttal review.
Thank you, Your Honor. It appears the main defense is that 79 people voted that Amy Chelini's doing a good job. I'm sorry, but whether or not 79 people think they're doing a good job and should be retained does not give them a right to violate the Nevada Code.
And I'm going to object. It's not 79 people, it's 79 lawyers.
So noted, Mr. Terry.
79 lawyers does not give Judge Chelini the right, the power, or the ability to violate the Nevada Judicial Code. And we acknowledge that there is no charging document at this time. That is no excuse for the inability or refusal of these respondents to accept at least some responsibility for their misconduct, to show at least some remorse, and not call this commission a commission that's aimed at doing a witch hunt. I think that's offensive. There's lots of things they brought up that are not issues. What male judges wear, that's not part of this case. Whether or not the question about the supermarket, it was just a hypothetical designed to try and get Judge Bauckham to answer the question. They talk about input. Input is allowed, but what they did was interfere. Input does not equal interference. We agree with them. This is not an employment trial. We ask you to judge the credibility of the witnesses. And in assessing the credibility of the witnesses, I'd ask you to consider the weight and value of the testimony and take into consideration the interest of the witness in the outcome of this case. Both of these respondents have a great deal of interest in the outcome of this case, and the commission should study their testimony very carefully. I believe that the prosecution witnesses stood up to a fairly blistering cross by my esteemed colleagues who went after them with every tool in their arsenal. I'd like you to take particular time in examining the testimony of Judge Tobiasson, who essentially called everyone who testified contrary to her a liar. Judge for yourself her body language and the way she acted. A couple of other notes. We agree that the administrative group, the administration, didn't always appear to do everything right, but working together should have been the priority for both the judge and the administration as the people testified. And we ask you and suggest that the commission needs to focus on the facts of the allegation, not the bickering between witnesses or whether it's an employment case or not an employment case, and just look to see, do these judges pose a threat? And based on their conduct, we submit that they do. Thank you.
Thank you. I appreciate the conscientious presentation of evidence that's occurred during this two-day proceeding. This matter will be under advisement. The commission will be deliberating about the facts and evidence that were presented, and then once the appropriate time is come to render a decision, or a written decision will be rendered by the commission. This matter is now adjourned. Thank you.